All right, I think we're ready. People may join us as we go on, but welcome everyone to Holland & Hart's webinar, Navigating the Rules for Manufacturing Medical and Safety Equipment in Response to COVID-19. Today, the presenters will include myself. I'm Maureen Reedy-Witt. I'm a partner at Holland & Hart in our Denver office. Also presenting today will be Lee Gray, who is another partner in our product liability group in the Denver office. Brent Johnson and Nathan Archibald, who are on our product liability group in the Salt Lake City office, and Sean Kennedy, who is with our government contracts and government affairs group in the Denver office. Sean doesn't do exclusively product liability work. The rest of us do product liability regulation work and regulatory work, and we do product liability defense work. Sean does government contract work and consults with us on issues that overlap, such as procurement and requisition issues, which will come into play in some of the stuff that we are going to discuss today. Let me first talk about the regulatory environment and the general environment that we find ourselves in. So the regulatory environment that we're in right now is quite unusual from our regular regulatory environment. Because of COVID-19 and the issues that it presents, there have been great many modifications in the regulatory environment for things that a number of you as manufacturers either are or may be interested in manufacturing because you have the capability to do so. It's a good way to keep your business running, and it's a way to keep your employees on the payroll. So some of the items that we're going to discuss today include personal protection or protective equipment, which includes disinfecting and sanitizing products. It includes face masks, gloves, gowns, and things like that. These are all highly regulated aspects of the medical world, and they're regulated through all parts of their production life cycle, including requirements for pre-approval of the products, registration of facilities that manufacture the products, and specific labeling. Depending on what the product is, it may be regulated by the FDA, by EPA, by the Alcohol, Tobacco, Tax and Trade Bureau, by FTC, by the Consumer Product Safety Commission, or by a number of them overlapping. However, the important thing to recognize is that in this current environment, many regulators are responding to the emergency created by COVID-19 by creating streamlined processes through which you can get products that you would like to manufacture approved, or stating that you do not need the normal approvals that you would otherwise need in a non-emergent environment. If we could turn to the next slide, please. The first thing you want to consider is whether or not what you are manufacturing or considering manufacturing is a regulated product. We're going to talk today about basically three categories of products that we found many clients are interested in making during this time, whether or not they ever made them previously. And one of the speakers is going to address each category of product, but let me just discuss them overall as an introduction. First, there's face masks, gloves, and gowns. And with those kinds of products, one of the first things you need to do is ask whether or not it is intended for a medical purpose. If so, then it's going to be regulated by the FDA. And there are different classes of devices under FDA regulation, which we'll get into perhaps in a little bit. The second is, if it's not intended for a medical purpose, then those are generally not regulated products. Next set of products are hand sanitizers. Those are FDA regulated over-the-counter drugs, but the TTB does regulate the alcohol ingredients of sanitizers, and sanitizers have to have certain amounts of alcohol in them to be true hand sanitizers. Finally, there are disinfectants, and there are two categories of that. One is non-critical medical application, which are general purpose. Those are jointly regulated by the EPA and the FDA. The critical medical application disinfectants, the ones that you would use in a medical setting, a surgical setting, an operating room, that have a high level of sterilant, those are regulated by the FDA as a Class 2 device. So that is the overarching landscape. We're going to talk about the particulars and go through those in more detail in just a minute. But if we could go to the next slide, one of the main things that you're going to need to determine is the product you're manufacturing intended for a medical purpose? And generally that comes down to, is it intended to be used in the mitigation, treatment, or prevention of disease? Or is it intended to be used by a healthcare professional or in a healthcare facility? We could go to the next slide, please. We're going to get into that analysis that I just went through with respect to the various categories of products I talked about: face masks, face shields, gowns, hand sanitizers, and disinfectants. But one thing all of you should be aware of generally, before we get into it in more specifics, is that the federal government did anticipate that we might find ourselves in a circumstance like this someday. And in December of 2005, they passed an act called the Public Readiness and Emergency Preparedness Act, or the PrEP Act. The PrEP Act essentially authorizes the Secretary of the Department of Health and Human Services to issue a declaration that provides immunity under federal and state law, absent willful misconduct, from claims of loss that are caused by, arise out of, or are related to or resulting from countermeasures to diseases. Countermeasures to diseases is a term I'll discuss in just a second. That's when the Secretary determines that these diseases constitute a public health emergency. This immunity applies to those who develop, manufacture, test, distribute, plan, administer, prescribe, or use these countermeasures. Just for your background information, the state of public health emergency for the COVID-19 virus was declared on January 31, 2020. Separately, the COVID-19 declaration necessary to trigger the PrEP Act immunity was issued on February 4th, 2020. So that's what we're talking about here. But in order to come within the PrEP Act, it's really important that you focus on a couple of things. One is that covered countermeasure means that you are developing, manufacturing, distributing, or any of the categories I described above, a drug, a medical device, or a biological product that's intended to be a countermeasure to the disease causing the epidemic or the pandemic. It has to be the manufacture, use, design, development, modification, license, or procurement is what triggers your ability to get coverage. And it has to be used to diagnose, mitigate, prevent, treat, or cure the disease that is causing the pandemic or the epidemic. This is what's really important here for purposes of the discussion that's going to follow. In order to get immunity under the PrEP Act, your product must be an FDA-approved drug or device, or something that's licensed under the Public Health Act, or it has to be an approved investigative device or a device under the investigational drug application or investigative device exemption. Or, and this is the most important category for everyone who is responding to COVID-19 by deciding to start manufacturing or retool their manufacturing plants or services or distribution services to provide things that they did not provide before, things like masks, face masks in particular, gowns and other things. You can get an emergency use authorization. That's an authorization that the FDA has created pursuant to the PrEP Act or in conjunction with the PrEP Act to allow for emergent approval of badly needed products that will help respond or be countermeasures to a disease that's causing a pandemic or an epidemic. There are really two primary routes to go right now. One is to get an emergency use authorization from the FDA, unless you already have an approved drug or an investigative drug or device. Or you can go under the guidance that FDA has issued, which in most instances says it will not object, basically meaning it will not enforce its otherwise applicable regulations that would control the devices that we're talking about today. So with that general background about the PrEP Act, I'm going to turn it over to Lee Gray to talk about face masks, which are one of the things we found most people are interested in manufacturing and that present certain issues that you may be interested in. Lee?
Thank you very much, Maureen. I am going to talk a little bit about face masks and shields in particular. These are a lot of the items that are in most shortage right now. And on April 2nd and a couple instances before then, FDA issued certain emergency guidance related to these items. Each new guidance superseded the prior one and took its place. The most recent one was done on April 2nd. And relates to face masks and face shields. Now, the important aspect here is what type of product that you have. And so face masks are generally the picture you see there in the upper, thank you, in the upper right-hand part of the slide. And those are masks that cover the nose and the mouth. And they may be surgical masks. They may be plain face masks that do not provide any kind of liquid barrier protection or particulate filtration. Basically, they're what you and I are walking around with all the time now, just the general masks that try to stop the flow of things from your nose and mouth from you to other people and try to keep things a little bit away that are coming from others as well. The second item, within the definition of face masks, you may have different levels of protection. So you could have a surgical mask, which is the same thing as a face mask, looks the same, but it has different kind of properties based on the materials that it's made of that does provide a physical barrier to fluids and particulates, and it meets certain fluid barrier standards and flammability tests. In order to make one of these devices and to send them out under the emergency guidance, you have to do the appropriate testing to determine whether it provides that fluid protection and filtration. The second item is the face shield over there on the right. It's kind of hard to see, but it's the glasses that this lady is wearing. The face shield does similar to a face mask with respect to the protection. It gives you a barrier to fluids and some particulates, but it covers your eyes in addition to your mouth and nose. So it covers, usually it's worn almost always in conjunction with the face mask, but it provides a little bit different type of protection, the fluid protection, and that is also being manufactured by a lot of folks now. And then the third type of device is the respirator, what I call the N95 respirator here. That's a disposable half mask that filters, that covers the nose and mouth and offers protection from particulate materials. N95 filtration is a certain efficiency that basically filters out 95% of all particulates. That's what most surgeons and most of the doctors and medical personnel are wearing these days to try to keep out the COVID-19 virus when they're treating people. They have specific requirements related to the materials they're made of and the testing that is done to get there. But you need to, with these kind of definitions in place, then the question of how you get these to the market now under these either emergency use authorization or the policy related to enforcement depends on what they're going to be used for. So let's move on to the next slide. And talk briefly about these two different things. The emergency use authorization is basically, as Maureen mentioned a minute ago, issued by the HHS director, and it is specifically related to different devices. And so it is a way to get your device through when the typically cleared devices are not available. So it's think of it as an alternative. It does require a brief overview by FDA to look at the performance, safety, and labeling of the product. So you do have to submit some things to them, but it is a very truncated procedure and is much faster than a typical clearance for, say, a Class 2 medical device usually has to have a 510K clearance, which requires pre-market notification, and these are usually weeks or sometimes months worth of evaluation by the FDA. The emergency use authorization is days and or sometimes hours. Basically, the FDA does a very quick look at your performance, safety, and labeling items that you're providing, and then sends you, and all this is done by email now, and can issue an EUA for your specific device. Once you get that, you are covered under the PrEP Act that we talked about before. Although there's this truncated approval process, it does waive other requirements, the other regulatory requirements, such as current good manufacturing practices, quality systems that are typically in place for medical device manufacturers, and the specific traceability, where each medical device generally has its own identifier, so they can follow that. The emergency use authorization is generally being used now with respect to the respirator products, and there is a respirator, the N95s, which are generally, or NIOSH, which is also a type of respirator. Those are both approved devices that would preferably be used, but in the emergency situation we're in, where they're in shortages, a lot of the FDA is issuing lists of different manufacturers who have set forth the emergency use authorization information to be listed there, and you can import and sell those particular type of devices if they're either certified in other countries, such as the European certification, or there is a KN95, which is made and certified in China. It has its own separate emergency use authorization, frankly, because I think FDA is a little bit concerned about counterfeit products coming out of China, and wants to make sure that certain procedures are in place to use those. By contrast, the enforcement policy is basically the FDA using its discretion to say, you're not going to get in trouble even though you're not following the specific regulatory requirements, such as establishment registration, pre-market clearance, and the other items that we just talked about. It's easier to get. You don't have to do anything other than tell the FDA with a notification email while you're doing it, what you're sending out. So what can you send out in that regard? Let's go to the next slide. And these are your questions that you need to ask to determine whether you can produce and market these items. First, is it intended for a medical purpose or not? When we look back at that, if it's there for the mitigation or trying to prohibit disease, that's what most people are wearing these for. That's what, or if it's used in a healthcare facility, those are going to be the medical purpose. That is an FDA-regulated item, and you need to go through the requirements from the guidance and non-enforcement policy that has come out. And specifically, as we just said, if that's in place, the FDA is not going to object to the lack of its typical requirements that it has. And but what you do have to do, the most important thing, is that the mask or the face shield or the gloves or the gown or whatever the device is doesn't create an undue risk. And the way that you avoid the undue risk is with specific labeling requirements. You have to label specific uses and non-uses. Most of the masks that are going out under the emergency non-enforcement policy are the ones that do not provide either particulate filtration or the fluid barriers. And so those, as long as you have certain labeling requirements that relate to the appropriate use of those, then you can get those out, and all you have to do is just notify FDA. And then that's the last item there. You just send them an email telling them what you're going to do, give them a copy of your label that you've produced specifically for these devices, and the volume. They're also trying to track how many of these things are out there, and that assists them in determining where things go and what is needed. And so with that, we can move on to the next topic, and I believe Nathan Archibald is talking about that.
Nathan, you might have to unmute your phone.
Yeah, am I unmuted now? Can you hear me?
Yeah, we can hear you now.
Okay, great. So we're talking about disinfectants. These are products which destroy microorganisms. You've probably read about the novel coronavirus. It's encased in a lipid layer, and disinfectants do a really good job of breaking down that layer and then killing the virus within. The first question in terms of regulation is, are you dealing with a disinfectant product or just a cleaning product? And that distinction comes down to what you claim the product will do. So are you claiming that your product will prevent, destroy, repel, or mitigate the virus? If so, then it's a disinfectant. However, if you're just claiming that your product cleans the surface or removes stains or washes away dirt, then it's just a cleaning product and it's not regulated, as we'll talk about further. So how are disinfectants used? The CDC recommends that you disinfect surfaces that are regularly touched. So doorknobs would be an example. And as you can imagine, in a medical environment, surfaces and devices are disinfected constantly. So we're talking here about, what are they made from? The typical ingredients, mostly alcohol, hydrogen peroxide, and some other chemicals I will butcher the pronunciation of. Okay, next slide. So how are disinfectants regulated? Well, as in with masks and with everything else, it depends on the intended use, where and how it's going to be used. The first type of disinfectant, per the regulations, is what we call a general purpose disinfectant. It means in the medical environment, it's intended to process non-critical medical devices and equipment surfaces. So rule of thumb, a non-critical medical device only makes topical contact with the skin. So EPA regulates general purpose disinfectants, and it does so under authority from the Federal Insecticide, Fungicide and Rodenticide Act, which is FIFRA. And disinfectants come under FIFRA because, as we talked about, they kill stuff like other pesticides, just on a smaller scale. So EPA regulation under FIFRA regulates the where. So the production must be in a registered establishment. They regulate the what, meaning that they have to approve before you go to market your disinfectant product, and that requires a lot of data, a lot of testing on the safety and efficacy of the product, as well as your labeling. So that pre-market approval is the biggest barrier to entry for anyone looking to newly manufacture a disinfectant product. So there's a couple of questions and a couple of pathways that you have under FIFRA. The first is you can submit a registration for a disinfectant that is identical or substantially similar to an already registered product. So that lessens, it doesn't eliminate, but it lessens the review requirements. The catch is, and there's always a catch, the catch is you have to compensate the company that created the original product. You can also, so you have to compensate them for their data, basically, and that can be, tens of thousands of dollars. You can also do a supplemental registration. So as a manufacturer, if you have a good relationship with a disinfectant manufacturer, they can designate you as a supplemental ancillary facility, whereby you can produce their registered product. Now, general purpose disinfectants are also jointly regulated by FDA, if for a medical purpose. Now, that makes them, for FDA purposes, a Class 1 device. They're an exempt device, meaning you don't have to comply with most of the 510K requirements for disinfectants. They're only general controls. Lee talked about a non-enforcement policy for certain masks and different products from FDA. The biggest question is, does EPA have a similar non-enforcement policy for non-registered disinfectant? And the answer to that is no, unfortunately. You would have seen in the news that the EPA announced that they were relaxing standards for many of their enforcement activities. Unfortunately, FIFRA is not one of them. To the contrary, we've seen stories of EPA, doubling down on efforts to enforce FIFRA as it applies to unregistered, illegal disinfectant products. Is EPA expediting their approval process? The answer to that is yes, but they won't engage with us regulatory lawyers in guaranteeing approval within any certain period of time, even for identical or substantially similar products. So it could take months. We just don't know. The usual, prior to this pandemic, it was 5, 6 or more months. FDA. Okay, next slide. So that's the general purpose disinfectants. There's also what's called high-level disinfectants or liquid chemical sterilants. So these are for use at the terminal stage in processing critical medical devices. So rule of thumb, a critical device is something that makes contact with sterile body tissue or body spaces. So basically something that's going to go inside the body is a critical medical device. So FDA regulates high-level disinfectants for medical use as a medical device. Now they're classified as Class 2 non-exempt devices, meaning that there's a whole 510K pre-market review. At present, there's a couple of dozen cleared 510K manufacturers for these high-level disinfectants. Now, because this 510K process is very similar to the EPA pre-market review process, there's a memorandum of understanding between the EPA and the FDA that FDA can take this one on by themselves. So EPA is kind of ceded ground as to the high-level disinfectants. So does FDA have a COVID-19 related non-enforcement policy for non-registered high-level disinfectants? The answer to that is yes. So at the beginning of April, FDA announced that, I'm quoting here, during the declared public health emergency, FDA does not intend to object to the distribution and use of disinfectant devices, which would include these high-level disinfectants, without compliance with various regulatory requirements such as the pre-market notification and registration. In their guidance, non-enforcement policy, they require certain risk mitigation measures be taken by a company that wants to avail themselves of this non-enforcement policy, including some performance and labeling requirements. So that's the good and bad news on disinfectants. Next slide. This is Brent, hand sanitizer.
Hello, everyone. I am covering hand sanitizers, and this is a product that I was blissfully ignorant of until I reached the age of 42 and married into a family that spends all day putting hand sanitizers on them. So I've been living the COVID-19 lifestyle since, 2003. Anyway, the hand sanitizers, this slide that we're looking at right here, is the regular way to do it, to manufacture and get approval for a hand sanitizer. So it's not really relevant or that relevant to what we're talking about, but it just kind of gives you sort of the lay of the land and how hand sanitizers work in the normal world. Hand sanitizers are an over-the-counter OTC product regulated by FDA, particularly the DP, which is known as a Division of Non-Prescription Drug Products. And the way if you were living in a normal world, the way you would get approval or be able to approval is not the right word. The way you were able to market this product was that you would find an OTC, over-the-counter monograph published by the FDA that has a formula for a hand sanitizer, because that's how FDA deals with these products. They have monographs, and if you find the right one and you follow its compounding and formulation formula, then you're great. We need to then register your establishment with FDA, and they will assign you a national drug code number. And then after that, you list the product with the FDA and submit the final label of the drug product. You comply with the FDA drug labeling requirements, and you're on your way. So it's not, manufacturing lawful hand sanitizers is not the hardest thing in the world to do, but in these trying times that we're in right now, FDA has kind of loosened everything up by issuing their temporary policy for preparation of certain alcohol-based hand sanitizer products during the COVID-19. And they call it a guidance for industry, which, always harkens to the point that if they call it guidance, that doesn't mean that they can't come after you, but they won't. But FDA is always clever about using words like guidance rather than regulations or policies when they're trying to be liberal in allowing products into the market. And this was issued in March 2020, and then it was updated on April 15th. And here's how we look at this. So the preamble, or part of the preamble to this guidance, starts with, if soap and water are not readily available, the CDC recommends consumers use an alcohol-based hand sanitizer that contains at least 60% alcohol, which is also referred to as ethanol or ethyl alcohol. Interestingly, I live in Park City, Utah, and when I went to my liquor store at the very outset of the pandemic, there was a prominent sign posted that they were limiting the purchase of Everclear to 2 bottles for a consumer. I didn't even know, frankly, that they sold Everclear at a Utah liquor store, but they do. But as you know, most potable alcoholic distilled spirits have about a 40% alcohol by volume. Everclear actually qualified as a hand sanitizer, I guess. Anyway, moving on. And let's move to the next slide, just so we're on the right slide. Okay. Because the public health emergency that's posed by COVID-19, FDA does not intend to take action against firms that sell alcohol-based hand sanitizers or prepare them, but there are some requirements. Number one, the hand sanitizer is manufactured using only certain ingredients, and here they are. You get to select one of 2 options. Number one is alcohol, ethanol. Again, this is usually what is made by distilled spirit companies, and it's not less than 94.9% ethanol by volume, so very high concentrate of alcohol. Or 2, it's an isopropyl alcohol as defined by the United States Pharmacopoeia. Okay, most of the the companies out there right now who are making hand sanitizers are doing it they're distilling companies basically, or some brewing companies are involved. So isopropyl alcohol isn't really what's being used for these emergency hand sanitizers. Okay, then once you pick your alcohol, ethanol or isopropyl alcohol, then you can add glycerin, hydrogen peroxide, and sterile water, which is basically water that's been boiled or otherwise purified by distillation. And that is the sort of the definition of this emergency hand sanitizer that can be marketed. There are some important things to note. First, alcohol that's used in these products must be denatured. And if you don't know what that is something is added to the alcohol to make it poisonous, bad tasting, foul smelling, or nauseating. The FDA wants that in their hand sanitizer. They don't want people recreationally consuming hand sanitizer. So the alcohol must be denatured. Second, you can't add any other active or inactive ingredients, which means, in particular, you can't add a scent to the hand sanitizer. Again, FDA is worried that people will buy hand sanitizer and consume it. I don't know why, but some people will. And then finally, it must be an aqueous solution. It's got to be water. You can't turn it into a gel, a foam, or an aerosol spray, although you can have a spray that isn't an aerosol, like a pump. The nice thing about the FDA's guidance, on top of being very specific and clear as to what can go in a hand sanitizer, is that they provide specific labeling that you can use on these emergency hand sanitizers. So if you're in the market, if that's what you're marketing or producing, all you have to do is go on to the guidance page, the FDA's guidance page, and you can see exactly how to label your product. Then finally, and this is very important, the FDA wants to make sure that you engage in really solid record keeping. The alcohol content must be very high, as specified in the guidance, and you need to make sure that you have records that substantiate the alcohol content of the hand sanitizer, as well as all of the other ingredients that are in every batch. If you do that, you're in very good shape. The one thing I'll mention before turning the time over to Sean is that the TTB, the Alcohol and Tobacco Tax and Trade Bureau, regulates, and to some extent, the alcohol, if it's ethanol, that is introduced in hand sanitizers. And again, as we talked about a few minutes ago, it's mostly distilled spirit plants that are making hand sanitizers right now. And so the TTB has something to say, and they issued their own guidance on March 26th. And that guidance says you don't need to get authorization from TTB prior to using what would otherwise be called distilled spirits or ethanol for a hand sanitizer. Any distilled spirit plant may remove undenatured, so it doesn't even have to be denatured or toxic or poisonous alcohol. They may remove undenatured or denatured ethanol from a bonded premises free of any tax for use by a state or local government to produce hand sanitizers. And in addition, they can themselves make hand sanitizer as long as they follow FDA regs and the emergency FDA guidance. And with that, I will turn the time over to Sean to talk about price gouging.
Actually, Sean, let me jump in here first on this first couple of slides on price gouging. So we've talked about the care that companies need to take in manufacturing the products and how wary they need to be. We'll talk for a minute now about the care in which they need to price these coronavirus response materials. Now, perhaps some of you intend to just manufacture them and give them away or sell them at cost. But for those who will sell at market price, with supply chains in flux and prices of raw materials spiking, companies do need to be wary about their pricing strategy. The first reason for that is that most states have specific laws prohibiting dramatic price increases in times of disaster or emergency, as do many cities. You'll see here on the slide there's a kind of color-coded map of the United States. The purple states on this map are the ones that have specific price gouging laws. So there's 29 in total. So I'm speaking here from Utah, so I'll give you as an example Utah Code 1341-201, which states that during a declared state of emergency, a retailer may not charge a consumer an excessive price unless the retailer's cost in obtaining the product has similarly increased. So this is an example of a price gouging law that only applies to retailers, not necessarily to manufacturers. But if you compare that to California Penal Code, Section 396, it prohibits raising the price of medical supply products by more than 10% after an emergency has been declared. And it does not just specifically apply to retailers. So in California, that is the law that applies, and California's governor has issued an executive order attempting to affect this restriction until September 2020. As another example, Florida. It's similar to California. Its law doesn't apply only to consumer products, but it doesn't have a percentage increase to look for. What it prohibits is, and I'm quoting here, an unconscionable price, which means, per their statute, where there has been a, open quote, gross disparity, close quote, between your price and the average price from 30 days prior to the emergency. So under these state laws, violations are punishable by fines and potential jail time. But of course, the likely bigger impact would be in the court of public opinion. As 3M and other companies are experiencing right now, no one wants to be the public face of price gouging. Let's go to the next slide. So typically when we're talking about pricing laws, it's a state matter and typically falls outside of federal jurisdiction. There is an interesting Korea War era statute, which is the Defense Production Act of 1950, which prohibits companies from hoarding or gouging, price gouging, what is called a designated scarce material. And similar to state law, willful violations of these provisions are punishable with fines and potential imprisonment. So that's a 1950 Act. Cut to 2020, March 23, President Trump signs Executive Order 13910, which triggers the Defense Production Act, and he empowered HHS to designate COVID-19 response resources as scarce materials under the Defense Production Act. A couple of days later, March 25, HHS did what it was asked and published its list of scarce materials. So these include the N95 filtering face piece respirators that Lee talked about, other personal protective equipment, face masks, other face masks, gloves, disinfectants, sanitizing products. So all the stuff that we're talking about today pretty much has been covered by this executive order. So what does that mean under federal law? Well, it means you can't accumulate any of these products for the purpose of resale at prices in excess of prevailing market. That is a very broad statement. I'm just reading from the Act. It doesn't give you a lot of context here as to what it considers or what a federal judge would consider the prevailing market price for any of these products. And a lot of you are finding that that notion is in flux. The Act also doesn't define what it means to sell in excess of the prevailing market price. So if you're $1 over, have you violated the Defense Production Act? So there are some open questions there. The other open question is, going back to the state laws we spoke about, a lot of times in a lot of states it requires an analysis of the increase in price before and after the emergency order. And problematically, if you were not selling these prior, then you don't have that easy baseline to use. So, when we're talking to people about these laws, our usual rule of thumb is don't stand out. Don't stand out like a rule of thumb. Have justifiable margins and markups And also, make sure that when you come up with your pricing strategy, make sure it's clearly communicated across your company. You don't want a rogue or uninformed employee getting your company into hot water. Okay, next slide, and passing over to Sean.
Great, Nathan, thank you. And so Nathan mentioned and sort of introduced the Defense Production Act, which of course has received substantial attention during this epidemic. You've likely seen it mentioned in news coverage or in the coronavirus task force briefings. But it's important to note that it's not new. In fact, Congress enacted the DPA, as Nathan mentioned, in 1950 to provide access to domestic industrial and manufacturing base that could be mobilized easily, quickly, nimbly for national defense needs. So, of course, defense contractors are likely familiar or more familiar with the DPA, as the Department of Defense and the intelligence community have utilized the DPA to issue rated orders for national security purposes for a number of years. So where this became certainly more relevant in light of the COVID-19 epidemic was President Trump issued an executive order 13909 on March 18th, authorizing the HHS to utilize the DPA for the purpose of defining priorities and allocations for health and medical resources, including the distribution of PPE and ventilators. So it's important to note that while the Defense Production Act is a broad and sort of wide-ranging law, it's governed and generally implemented by regulations under 15 CFR Part 700, which are called the Defense Priorities and Allocation Systems Regulations. So the Department of Commerce oversees the DPAS regulations, who in turn has the authority to delegate various executive agencies, including HHS, to place priority ratings on contracts. So DPAS generally contains two priority ratings, DX and DO. DX rated orders are the highest priority rating and will take precedence in terms of fulfilling that order over any DO rated order or any non-rated order. And then similarly, in the next rung, DO rated orders fall below DX, but they do take precedence over any non-rated order. So many of you that may not be familiar with DPAS, obviously the question becomes, how do I know if my contract is a DPAS rated order? The contract by regulation is required to designate the appropriate priority ranking. And commonly you will see that at the very top of the contract, usually box 2 or one of the top boxes of the contract that designates the DPAS priority rating. 2, every DPAS order is required to state a required delivery date, and that's the date upon which the goods that are being ordered through this rated order must be delivered to the ordering entity. And then, of course, the contract must set forth terms and conditions requiring compliance with the various DPAS regulations. So with limited exceptions, it's important to note that a company who receives a DPAS rated order is required to accept that order within a specified time period. It's 10 working days for DX rated orders, and it's 15 working days for DO rated orders. There are some special circumstances that may shorten that time window, depending on the type of order and why the order is being made. So it's important to consult the regulations to make sure that you are familiar with and understand those time frames. But that said, the DPAS regulations set forth some exceptions where a company may, so permissively and must, mandatorily reject a DPAS rated order. Generally speaking, those reasons for rejection relate to either a company's inability to fulfill the order by a specific date, or the ordering entity refuses to meet regularly established terms of sale or payment. However, it's important to note that the regulations say that if a company rejects a DPAS rated order for schedule difficulties, the company is required to inform the ordering entity of the earliest date upon which delivery could be made, and then is obligated to accept the order on the basis of that date. So in addition to the ordering capabilities, the DPA may also be used to preserve and allocate resources for national defense purposes. So for example, on April 3rd, 2020, President Trump issued a memorandum directing HHS and FEMA to allocate certain medical resources used to combat COVID-19 for domestic use only. So therefore, those specific resources, those specific goods are prohibited from export to other countries at this point. So important to note that in addition to the rating of the order and the prioritization of those orders, the DPA can also be used for allocating resources and ensuring that they're available for national defense purposes. So again, and this is just a very quick summary of DPAS and the Defense Production Act. We note that, of course, as the COVID-19 pandemic is evolving on a day-to-day basis, it definitely remains to be seen how the administration will continue to utilize the authority under the DPA. That said, companies working with HHS or other executive agencies who may be purchasing goods that are used to combat the COVID-19 epidemic should obviously familiarize themselves with the DPA and the DPAS regulations, and of course consult with legal counsel if you have any questions. So with that, I will turn over to the next slide.
Okay, it's Brent Johnson again. I am now going to talk about what I speak at various presentations around the country about false claims and false advertising. I do a lot of that work in California, where I also practice, and it's always referred to as the fun part of the presentation. I mean, normally I'm preceded by people who talk about how to make sure that your font is 1/8 inch or more on cosmetic and food labels, and then I get to come in and show to the audience what the rubes do when it comes to false advertising. And it's funny because since I do enough of that work, it's not simply rubes that engage in false advertising. It's people who are not exactly sure what they're doing. So I'm now going to talk very briefly about the COVID-19 related advertising or marketing claims. And the thing you need to know up front is that there's always a conflict in jurisdiction between FDA and the Federal Trade Commission, or FTC, regarding the authority to regulate claims. FDA's view is that they are limited to claims on labels, and yet they've expanded that jurisdiction by basically asserting that any information on a website should be considered part of the label. The Federal Trade Commission, FTC, on the other hand, basically views almost anything as advertising, including label claims from time to time. So you can get in trouble with one or both federal agencies if you engage in false advertising. The other thing that's important to note is that the amount of false advertising that goes around in this country and the world is staggering. And therefore, federal agencies like FDA and FTC, they focus their priorities. Recently, they've been focused on Instagram influencers, for instance. That's become a huge issue for them because practically it's a huge issue in our internet economy. COVID-19 related claims is obviously a huge issue for both agencies because it's current, it's important, and COVID-related claims take advantage of very vulnerable populations of people who are scared to death of contracting the disease and dying. And therefore, both FDA and FTC are very active in policing media in order to make sure that consumers in the United States aren't being fooled by claims. Let's move to the next slide. This is Jim Baker. I grew up in the 70s and 80s. I remember him from PTL along with his now departed wife, Tammy Faye Baker, who divorced him after, I think it was his IRS troubles, but he had several different types of legal troubles. And he's still around, and he still has a program. He works out of Missouri, and he basically touted this product here, the Silver Solution. And I actually have the transcript, or at least portion of it, from one of his broadcasts. And he had an expert by the name of Cheryl Selman on with him, a health expert. And he said, this influenza that is now circling the globe, you're saying that silver solution would be effective? And Ms. Selman responded that, well, let's say it hasn't been tested on this strain of coronavirus, but it has been tested on other strains of the coronavirus and has been able to eliminate it within 12 hours. Totally eliminate it, kills it, deactivates it. She then continued and said that silver solution, quote, has been proven by the government that it has the ability to kill every pathogen it has ever been tested on, including SARS and HIV. And then, apparently, and I have not seen this on the bottom of the screen, popped up a statement that said 4 4-ounce bottles can be yours. A message on this, and it's $80 for just $80 for 4 4-ounce bottles. Well, they received an FDA warning letter. They also received a warning letter from the New York AG, who's very active in this kind of stuff. They also were sued by the state of Missouri for false advertising. So that kind of gives you an idea of what some companies are doing in terms of I won't say even pushing the envelope, just violating FDA and particularly FTC law. And then let's turn to the next slide. This is a product that was touted on Alex Jones's website, InfoWars, and he posted a video on March 10th that said, Alex Jones, deep states, using coronavirus fear and panic to destroy our country. And at the approximately 13-minute mark, it states, regardless of how deadly this virus is, if it kills you, it's bad news. So I would advise listeners, just for your everyday life anyway, to boost your immune system. We have the products that are documented on record to be good for your body. I mean, nanosilver is on record taking out viruses and bacteria. It's in our entire line of high-quality silver products, and it's patented. It's amazing. It's the Super Silver Wound Gel. It's the Super Silver Toothpaste. It's in the Super Silver Blue Toothpaste. We're very close to selling out at InfoWarStore.com. So that's kind of how that was presented. And again, if you read the ads closely, if you listen to the broadcast closely, they try really hard to kind of just stay on the line. I mean, they don't represent this. Will, if you have coronavirus or if you're scared of getting it, use this product and you won't. But they do, they come very close, and that drew FDA and FTC warning letters to InfoWars, and Google even deactivated or dropped the Android app for InfoWars. So that's what we're looking at. By the way, CBD companies have also been issued warning letters by FDA and as well as the New York AG. I mean, CBD, as we all know, is the Wild West of products these days, and there's they tend to make claims that they should not be making, and so they've drawn attention from FDA, FTC, and the New York AG's office. And then finally, if that's not bad enough, there's also been a class action lawsuit filed against a company in California, of course, claiming that the company's claims about virus protection were unfounded, and this company now has to deal with that issue on the litigation front and all of the costs associated with that going forward. So those are, the idea here is if you sell these products, you need to be very careful that you don't make claims about that in any way suggest that they will cure, mitigate, or reduce the risk of contracting them unless you're on very solid ground, you have substantiation, and basically you've looked at FDA and FTC guidance and you fall within a safe harbor of some kind. And that's all I have on that. So I'll turn it over to, I hope, Lee. Are you going to wrap it up?
Yes, Brent. Thank you all for listening. I think we're right at about an hour here. I think that the takeaway from this is that we are in the middle of a big pandemic and emergency situation, And although there are a lot of regulations and rules related to medical devices, it is okay for non-medical device companies to dip their toe in the water of making medical devices, thanks to emergency rules and making things more available by the FDA and the other agencies that are involved as well. Recently, FDA did make a statement when they were discussing some of these rules with respect to face masks, and they said the purpose of our guidances is to actually allow maximum availability and regulatory flexibility for these products, including those outside the U.S., and to allow importation as long as you follow recommendations for your specific device. So it is good for companies to stay in business and make these products, and our regulatory agencies that normally have a lot of requirements have really relaxed those to allow fast production of these. So thank you all very much for listening. We appreciate your time, and I don't believe that we have time for questions now, but feel free to contact any of us if you do have direct questions, and any of us are happy to chat. Thank you very much, and have a good day.